Mark Wolber, our legal correspondent, has returned. Hey, Mark, how are you? Well, we were speculating that you could go to the beach here today and tomorrow if you wanted to.
I would love to do that. If I didn't have other things to occupy my time, I probably would do that.
A couple of reasons we wanted to get a hold of you today, one of which the Entergy Corporation is closing down the nuclear power plant in Oswego. Governor Cuomo wants to pursue legal avenues to put a stop to that. Will he be successful? Does he have any chance of being successful there?
I don't know the answer to that one. Generally speaking, when someone has a private enterprise, they're free to open, they're free to close. There are some specific regulations for energy-producing entities. They are regulated more carefully than an ordinary private enterprise. If you are operating a store or a restaurant, that's your choice whether to close or not. When you're operating a power plant that's supplying power, you have other regulations that are involved. There are federal regulations, there are state regulations. That's something that's called in economics a natural monopoly if they're the only ones producing that, and you can't just pull out and leave people without power. That's something that you can't do. Even, for example, with National Grid, if a customer doesn't pay a bill, they can't just cut the customer off. They can't just stop providing heat and electric because that could be a life-threatening situation. The cable company can. They can cut your cable off because that's not a life-threatening situation.
Mm-hmm.
So they have a lot more freedom as to what they do. But with an entity that supplies a service which is deemed necessary for life, there are regulations in terms of when they can curtail their operations. So there may be some issues related to that because it is deemed a necessity and there may be people relying on it where there is no good substitute, and that's the key. There may be no good substitute available for that. It may leave people without power, and that could be a life-threatening situation. So I think the governor may have some basis for success in that lawsuit.
Mark, today is the day to get out and vote. Are you going to exercise your right, or have you already?
I haven't yet. Unfortunately for me, I don't have. I live in the town of New Hartford. There aren't really too many contested races in New Hartford that we're looking at. I think the biggest contest that's going on is probably the mayor of Utica and the city judge in Utica. Those are the two probably most significant races in our community. And since I don't live in the city, I'm unable to participate in the election of either one of those people. I would suspect that the results of those two races are fairly predictable. However, those are probably the two major races in the community. So on the way home, I probably will stop. There are some local people running, but it's nothing like the two that we have in the city of Utica. Those are the hot ones. I think they schedule those city elections. I don't know about the judge, but the reason that there's a judicial spot opening is because Judge Bolzano is retiring. In the state system, once a judge reaches age 70, he must retire on December 31st of the year that he reaches age 70. So John Bolzano will be 70 on December 31st, so that'll be his last day to serve. It's interesting that his birthday was early in January, so he got to serve an entire year of being age 70. If he turned 70 December 1st, he would only have a month of being age 70. You can contrast that to the federal courts where the judges are appointed for life. So in the federal system, they can stay until they die. And the state court system, once they hit 70, that's mandatory retirement.
And then, Mark, another political candidate, Doug Joslin, represented himself in court this week against the stalking charges that have been levied against him. Well, was that a good idea or not?
Well, I saw a little bit of the coverage on that this morning, and I heard him speak, and based on what he said, it may not be a good idea. He suggested first that he wanted to bring a motion for a speedy trial. Well, a motion for a speedy trial only exists after sufficient time has lapsed, and then you move to dismiss because you've been denied a speedy trial. You don't move for a speedy trial. There's no affirmative motion that you make asking for a speedy trial. It's simply that the trial gets scheduled, and if it gets scheduled beyond speedy trial rules, which are not that specific, to be honest with you, when somebody's out of custody, they have to show prejudice for the delay, and that may cause some issues. So that's one. He also said he wanted to stop information from being disseminated to the media. That's very unlikely to happen. He said he wanted to suppress a statement from a witness because he felt the witness was lying. You can't do that. The purpose of the trial is to test the credibility of the witnesses. You can suppress sometimes your own statement because you claim that your statement was given in violation of your constitutional rights, and you can seek to have your own statement suppressed from the trial. And unless the other person is a co-defendant, which there are none in this case, it's nearly impossible to have the statement of another witness suppressed before trial. That witness gets to testify. You can test the credibility in the courtroom as to whether the person's being truthful or not, but it's not something that's usually the subject of the pretrial motion. So when I listen to that, I'm listening to things that this person is planning to do which really are not recognized in the criminal field. He is entitled to a trial. He can represent himself at the trial. He did say he wanted to make a motion to dismiss, and I can tell you now that in a criminal case, the only basis for making a motion to dismiss is if the supporting deposition is inadequate. If there is a deposition attached to the papers, whether it's true or not is not the issue. The question is there enough information there to support the charges? And if there is, then the motion would be denied. A motion to dismiss in a criminal case is not a test of the credibility of the witnesses, who you believe and who you don't believe, or who's being truthful or not. It's simply to say, do you have a witness, some witness or some evidence to support the charges that have been made? And if there is, that motion is going to get denied.
Great.
So and when I listen to what he said and how he intends to handle the case, it's apparent that he doesn't really have a handle on how the criminal procedure law works, and that could very well work to his detriment. You can sometimes handle a case by yourself, and there are cases where people have been successful, but as far as these pretrial procedures go, it's very difficult for someone who's not familiar with the law to handle the pretrial part of it. The trial himself, I mean, he can speak and he can cross-examine witnesses, but the judges will tell him that the same rules of evidence that apply to an attorney handling the case will apply to him. So he can't get into hearsay, he can't ask leading questions, and he can't make speeches during his questioning, which is the mistake that most people make because most people don't understand those things.
All right, Mark, thanks for your time, as always.